So it's good to see everybody. It's been a little while. I think we went a month without doing this. And so we've got 2 months of activity, which has gone on. As I typically do, I'll give you a little summary as to what has been going on, and then I'll open up the floor to questions. And as always, I will do my best to answer them as completely as I can. And if I can't answer something, I will tell you. If I can only answer something partially, I will do that. And we will go from there. So, as you know, at the end of March, beginning of April, we had a report in front of the court. And in addition to that report, I had issued a recommendation to the judge regarding benefit cuts as well as application processing. Quite simply, I asked the judge to allow me to defer for at least another 90 days any decision on benefits or cuts on benefits, and I'll talk about that a little bit more in a second. And I also asked the court to allow me to, for lack of a better way to put it, flip the switch and allow applications to be processed. That was both elections that had been submitted prior to or just upon me being appointed as receiver in August, as well as any applications that had been submitted and not acted upon, either had been submitted just prior to me being appointed or September, October, November. And if you recall, the judge had taken the position and clarified in his order that anybody who filed an application, their place in line would be preserved. Meaning that if you filed your application in September, not only would that application be processed before the October, November, and so on applications, but you would be given essentially a retroactive check as if your application had been properly filed in September. Now, the one point on that I do need to clarify for everybody is, as some of you may know, especially those of you who are collecting benefits, when you file an application with the benefits administrator, they take the application, they review it for completeness, they then do the calculation for that, your benefits, and they may ask you for additional information, and then they eventually send you an election form, which gives you your options under the plan as to what you can choose. That process generally took about 4 weeks. So if you submitted an application on September 1, the first time that you would be able to receive a benefit check would be October 1. Depending on timing, it might actually even be November 1. So you weren't entitled to benefits as of September 1. You were entitled to benefits as of the time that your election was provided to you. So in order to be fair, I have actually asked, or maybe I should say, in order to be as fair as I think I possibly can be on that, is I have asked Angel to process applications. First in should be the first processed, and to attach to it, I believe it was an 8-week, because of the volume that we have, basically an 8-week processing time. If they could process your application sooner than that, then I would use a shorter time frame. But at the very least, it would be an 8-week processing time, even if it took them 10 weeks to get you your election. Meaning that your retroactive check, if you submitted an application on September 1, your retroactive check would be as of November 1 going forward. I had to do that because there's no way to go back in time and figure out exactly how long it would have taken them to process an application. So on the ones going forward, we obviously can, but on the past ones, we had to find a time frame that seemed reasonable. They typically told me that to process applications under ordinary circumstances, that processing time frame was 4 to 6 weeks. With the volume of applications that we have, I think they are processing about 140, 145, that would take more like 8 to 10 weeks. So I basically tried to take the average of that and use that as a guide. Going forward, obviously, once all those that are in the queue have been processed and we get back on some ordinary schedule, then we'll be back to the ordinary schedule. But for those that have been waiting, you will be getting a retro check, and that retro check will be calculated within the 60 days or shorter. It depends on what Angel does, but at least within the 60 days of the date that you filed the application. So that's that with the application. So they are processing. I believe the elections, which were already done, it was just a matter of processing those, will go out in the next. They're going to go out in the next check run. So if you had an application, I think there were 18 of those. If you had an application that had gotten to the point of election and you submitted that to Angel just prior to or just after the receivership started, your check on that election should be coming in the next round of checks. If it's an application, then it's the process I just described. Excuse me. With regard to benefit reduction, I try to use my words very, very carefully. When I asked the judge to defer forcing me to make a decision on any reduction on benefits for at least 90 days, I really do mean at least 90 days. So what that means is that there won't be a decision before then unless there is something dramatic that happens, and I don't foresee that. And that does not mean that in the 90-day period or on the 90th day that there will be a reduction. I may ask the judge to further defer. And for those of you who are at the hearing, this will be repetitive. For those of you who read the pleading, it may be repetitive. And for everybody else, this is new information. The reason why I asked the court to allow me that 90 days, at least that 90 days, is because among the different things we're doing, which are investigating potential claims and all that goes into that, there is what I've talked about at these meetings before, the Pension Benefit Guaranty Corporation. And a theory that we have, a couple of arguments that we've raised with the Pension Benefit Guaranty Corporation is that, one, this plan, which has historically been treated as a church plan, was actually an ERISA plan and should not have been treated as a church plan. The other argument is if it was a church plan, I can now elect, I have not yet, but I could potentially elect to be treated like an ERISA plan. Under either of those scenarios, I need to comply with ERISA, which is the federal law. And my concern is that until we get to a point with the PBGC where they are either saying to us, we've heard your argument, we've looked at the materials, and here's what we feel the circumstances are, I don't want to do anything that could potentially jeopardize the plan and your recovery if PBGC were to be required to provide coverage. So if we were to do something that as a church plan would not violate ERISA, but if I were correct in an argument that it was an ERISA plan would potentially violate ERISA, that would possibly preclude PBGC coverage. It could require the plan to pay several dollars in fines, and I don't want to jeopardize the plan in that way. So there's kind of a balancing act between not taking a reduction and allowing the erosion of funds from benefit payments and things like that to happen as it has been, and not make a change, or to make a change that would slow the erosion of funds, but then somehow might preclude some type of coverage or result in some penalty. So based on that, after discussions with the judge and discussions with the independent investment manager as well as the actuary, I've decided, quite frankly, that staying the course, the status quo as it existed when I came in, is the best course of action, because at least nobody can say that I've done something different from what I inherited as receiver. And at least I maintain that consistency. Again, that may change. We spoke to the PBGC. Today is Monday. I believe it was a little less than a week ago. They advised they're still looking at the situation. They are still collecting documents from the parties that they have subpoenaed, and they have not yet made a decision yet, and they did not give us a time frame for that decision. So we're going to give them a little more time, because the one thing that we did say is we understand that they are not required to make a decision in any time frame. However, we have some things that we need to do. We've got litigation that we're investigating, and there's a point where I'm going to need to take action with special counsel to preserve claims that we have against other parties, and that may trigger us to act with regard to PBGC before PBGC is ready to act with us. So the timing is this little dance, and quite frankly, my request to the judge was to not upset any portion of the apple cart without knowing which direction we were going in first. So as of right now, again, barring any major change in the market or change in circumstances, status quo is being maintained for at least 90 days. And if things continue in 90 days as they are today, it would not be odd for me to ask the judge for an additional period of time to not make changes. Okay? So that's where we stand right now with applications. That's where we stand right now with benefits. Everybody should continue to receive. If you've been receiving benefits, you should be continuing to receive the check in the same amount that you've been receiving. Some of you may have seen a little uptick in the amount of money that you've been receiving as a result of some changes to the tax laws. But that's as a result of those changes, not as a result of anything to do with the plan. And everything else is maintaining. Your applications will be processed, and those of you who did file applications will start to see your benefits once those applications are filed. And you'll know when that's going to happen because you will receive an election form in the mail, which you're going to have to send back, and that's what will trigger the ability for you to start collecting those benefits. Other than that, I'll give you a quick update on the litigation. I don't know if anybody saw the Go Local interview that I did last week. As I said to Josh Fenton of Go Local, I had that interview probably 48 hours a little too soon because in that interview I had stated that although we were having problems with some of the parties with regard to document production, we were in court quite often trying to compel production of documents, that it seemed like at least now all parties were complying with the deadlines that either we agreed to or that the court had set, and we had received a huge volume of documents and people were still cooperating. Well, about 2 days later, Prospect filed a motion objecting to a subpoena that we had on a number of different grounds. And now we are dealing with that. We are not at the point where we're going into court yet to ask for the court's intervention. Still hopeful, as we always are, that we can resolve it among the parties, which is always my preferred way and the judge's preferred way, quite frankly. But if not, you may see us in court again trying to compel Prospect Medical Holdings to provide documents that we have asked them to provide, and now they are objecting to providing those, at least on the time frame that we've asked. With that, the special counsel has reviewed, at this point, it's probably over 800,000 documents. The important thing to know there is each one of those documents has to be looked at. There are many documents that take a second to look at, and you realize very quickly that they're not relevant to what you need to look at. There are others that take substantial time to read, absorb, and assess. And you don't want to miss a document that either will help to solidify your belief that there's a claim, or that may completely undermine what you thought was a theory for a claim, and then you get embarrassed when you go in front of a court and say we've got a claim against them, and then they show up with the one document you missed. So we have to look at everything. And we are looking at everything. We are, as I said, at the March-April hearing to the judge. Special counsel is going to make a report to me, not to the judge, not for public consumption, because it's an attorney-client privilege issue, as to what special counsel believes are the viable targets for any litigation, if there are any, what the potential recovery they see in that litigation, the claims, the value, and the potential recovery, and what their recommendation is with regard to commencing litigation. We have not had that discussion. That discussion will likely happen. We're close to the end of April now, so it'll likely happen in the beginning part of May, maybe the middle of May. And that's going to be a preliminary discussion. It won't be one meeting with, okay, go do it. It's going to probably be an evolution of discussions because I'm going to have questions. I certainly have my theory on certain things. Special counsel has their theory. They've reviewed the documents, and so it's going to be a discussion. It's going to be a reasoned decision as to what we do. Another question is going to be where we do it. Do we do it in state court? Do we do it in federal court? And that all depends on who the action's against and what we're seeking. So there are a lot of things that go into it. I'm hopeful that we will be in a position to at least start to file complaints against parties that we believe have some accountability here sometime in June. But it all depends on how things go and the information we have and the timing of things and everything else. So it could be earlier than June, it could be later than June. That's kind of my hope in terms of a time frame. Other than that, we're continuing to do what we have to do to maintain the plan. I have had a number of meetings, phone meetings, because they're located out of state, with Mercer Investments, who is the discretionary investment advisor for the assets of this plan. I've had those discussions because, as anybody who's read the paper over the past 3 months knows, there's been volatility in the market from a period where we were having not only some growth but some calm in the market. And that calmness seems to have started to erode a little bit. And volatility isn't necessarily bad, but I wanted to know how it impacted this plan and this plan's investments. Because the one thing I did not want, and I've said this before, is I don't want a dramatic event in the market to occur that would be adverse to the plan and have all of a sudden our position drop dramatically. So while I certainly do not want to liquidate everything to cash and then just start paying out benefits like that with no growth, I also don't want to have the investments at a point where it's an aggressive investment portfolio that is subjected to a lot of volatility and a lot of potential problems with that volatility. As a result of those discussions, the investment manager, as they have to do on at least an annual basis, has made recommendations to me to change allocations, not necessarily the investments themselves, but how much of the plan assets are invested in certain pieces. I've looked at that recommendation. I've approved that recommendation based on their expert advice and our discussions, and those changes will take approximately 90 days to implement. There are some time frames that are required under each one of the investments for notice and things like that if you're going to be taking money out and liquidating funds. But so that's in process. We approved that about a month ago. Is that about like 3 weeks ago or so? Yep. So we're about 2 to 3 weeks into that process, with another 2 months or so to go before those all take effect. Again, it should not. What it'll do is it makes the investment allocation slightly more conservative. I would not call it a conservative investment portfolio, but a more conservative investment portfolio, and one that the investment advisor, who has the discretion and the expertise, believes is appropriate based on where this plan is today in terms of its value, what I have told them in terms of potential for future contributions to this plan, as well as the monthly drain as a result of benefits and a projected drain as a result of potential applications and future benefits being paid out. So all of those things have been taken into account to come to where we are today with the allocation decision. And it's not like anything in this case. I've said this before. Nothing is carved in stone. If something happens and they call me up and say, Steve, this happened in the market, it was not anticipated, we think a change is necessary again, then we will make that change. Or if something happens that I at least want to hear from them why a change is not necessary, then I will make that phone call as well, just to make sure that we're dotting our I's and crossing our T's. I could also tell you that, I'm a lawyer. I'm not an investment professional. And so one thing I have also done is I brought on an independent consultant at this time to assist me. So when the discretionary investment manager makes a recommendation, I've got another set of eyes, a professional who this is what they do, who can look at it and give me a sanity check and say, yep, that's not inconsistent with what we would do, it makes sense, or it doesn't make sense, and here's why, and I can push back. So at least it gives me a check on what the investment manager is doing, so that I can feel comfortable that what I heard and what I understood is actually consistent with what they intended to communicate to me. So we're doing that as well. Beyond that, is there anything that you can think of? No? Okay, we did update, what? Okay, we did update the frequently asked questions on the website. Did we do that yet? Did that get posted? Okay, so we updated the frequently asked questions, and we do that periodically based on the questions that are raised at these meetings, based on things that come up at the advisory committee meetings, and based on the emails and the phone calls that you guys bring to either the dedicated phone line or the email. When we get a large volume of the same or similar questions, we update the frequently answered and asked questions so that everybody can benefit from the answer, because it appears to us that many people have that same question. With that, as I typically do, I will open the floor to any questions from anyone. If you could come up to the mic, please. Okay.
I have a lot of boys. So I just want to know, so we'll get a check for May, June, and July. Is that the 90 days you're talking about?
If I guess if I can answer that as an example. So the question is if we're talking about a retro check with the benefits, how will that work? If you sent your application in to Angel on October 1.
For the retirees that have been getting their checks regularly.
For the retirees that have been getting their checks regularly.
The 90 days. You say 90 days, we'd still be getting our checks, and I just want to know if it's May, June, and July. April, May, and June.
Oh, you mean the 90-day period? I'm sorry. Yes, so when I asked the judge to extend it for 90 days, the order got entered. What about it? From the hearing. From the date of the entry of the order, which was about 2 weeks after the hearing, a week or two after the... Okay, so the order was entered on April 6th. So according to the terms of the order, the deferred process would be 90 days from them. So you're talking May 6th, June 6th, July 6th. That would be the first time that anything would happen. I will tell you the judge, for those of you who were there, and I believe it was in the order as well, asked me to give a report again in 60 days. So I am scheduled to give a report May 30th or 31st. The judge may ask me where things are at that point. I don't foresee, as I stand here right now, I do not foresee asking the judge to change anything that I asked at the end of March. It's always possible because things change all the time. But as I sat there then, and as I sit here now, it's my intention to maintain status quo at least until July.
And I also, do we have enough money in the account for all the new people being processed? And if they get if they take like the monthly, that's fine. But are they going to be getting the option to take a lump sum? And will that be enough money in the account for everybody?
The answer to that is based on the applications that we have. I did present to the judge basically what I believed and what the actuary told me was the worst case scenario in terms of cash. Right now we have approximately $85 million. If those applications are processed, then, or actually what I said to the judge is if I make no change, then we're right where we are. We've been using $850,000 a month. Those applications that are going in, if everybody chose the monthly amount, would raise the amount by, I believe the calculation to the court was about $65,000 a month. If some people elect the lump sum, that's possible to make a change, but Angel is going to let me know what the elections are coming back with, because I do want to make sure that as I've referred to it, my term, there's not a run on the plan, and that could either mean hundreds of applications going in, more than what we've already got, or everybody asking for a lump sum. Again, my dilemma on all of that is if I make a change to the plan, then I'm potentially violating that plan, and I could be violating ERISA. So I have to do a little bit of a balancing act between what I think is best to preserve the plan as much as possible without somehow undercutting a future claim that we may make or have.
Thank you so much for both of you, because you've done so much to try to save us, and we appreciate it.
So it's hard, I will say to those of you who have spoken to her, this is Julie. Julie and I have been together for a very long time, and I'm not ashamed to say that she's the engine that makes everything go in the office. So she's the one who is responding to things and bringing the things to my attention as I'm running in 50 different directions. She's running in the other 50 and pulling me over to the things that she needs to do. So she's really the person you should be thanking on a daily basis. Any other questions?
Good evening.
Good evening.
When we joined the pension stuff and started the withdrawal stuff, I don't remember anyways in the forms that we filled out that there was a one-time deal of withdrawing a certain amount. So when did that start?
That's when a application has been processed. Now the plan has changed over the years, so I'm not exactly sure when you're retired in relation to how the plan has maybe either been modified or restated. But it is my understanding that for quite some time now that the election options, there were, I believe, 3 election options primarily that any pension holder could pick, one being a lump sum payment.
4 years ago, and I asked them about that, and they said there was no lump sum.
There was no option for a
There
lump
was no, there was one that we have, we get our full pension, or for 10 years we could get a partial, because the rest of the pension would go to
a beneficiary.
To a beneficiary.
Okay.
And those were basically the 2 options we
Those are
had.
the options that you all have seen thus far are the same options. I have not allowed or created a new option. I will tell you that in connection with the work with the advisory committee, which if we get to a point where we have to modify the plan, or I think it's absolutely necessary to ask the judge, then there are different options that are on the table, and a lump sum payout may be one.
I can understand that in the future, but I just don't remember it when we would process it, our information.
If it was not an option before, it's not an option now.
Okay, thank you.
We never had a written statement about anything when we retired, to be honest with you. All we did is we got a letter saying, this is what you're going to get, and that was it.
No, they gave you
That's all
options, though.
they said.
They gave you options.
And I have my original letter. I'll bring it the next time.
Okay, bring it to me so I can see what because I've obviously signed off on the more recent elections, and those elections have options, which are the 2 that were just described. You can receive a pension of X, or you can do it for, it was either a 10-year or 20-year period with the balance going to a beneficiary, and it was a reduced amount as a result because of the amount going to the beneficiary. So there may, again, depending on when you retired, and depending on what the status of the plan was.
It didn't even give us anybody to contact if we had any questions about. All it was just a regular piece of paper saying, this is what you're getting a month, and that was it.
I'll take a look at, if you could bring that in. That may have been, I don't know if Angel did this or whoever the actuary was at the time, they may have given you kind of a statement of, here's where your benefits are today, and if you were to claim benefits today, this is what we estimate your benefit payment would be.
I'll make a copy and mail it to your office.
That'd be fine, thank you.
Okay?
Hi.
Hi, I was just wondering if you must have seen it in the paper, that Prospect and Charter are offering to buy Memorial Hospital, and I wondered if you could give us your thoughts on that. I'll sit down for this.
All I'll say is that I've got enough to focus on with the St. Joe's pension. I am aware of the deal. I've got my own, just like you, as a citizen of this state and as somebody who is watching what's going on generally, I've got my opinions. Obviously, with Prospect having a role in this case, I'm always interested to see what other parties that are involved in this case are doing outside of this case, not just Prospect, all of them, because it sometimes, and I'm not saying this is one of them, but it sometimes tells a tale of that may be different than what they're saying to us. I'm not saying that that's the case with Prospect, but I keep my eyes open. If it's something that the powers that be, which are not me, think is a prudent decision for the state, then so be it. As somebody who's been involved in hospital transactions before, Julie's been there with me, I've got my opinions on whether or not that's a good deal, but I'm standing here, I'm not trying to buy Memorial Hospital, so that's all I can say about that.
I see it as a thorn in our side.
It's, from the perspective of this case, my own personal opinion, and this is not a legal opinion or anything. It's if Prospect is in this case, and again, I have not filed suit against anybody, so Prospect is not being sued by me as the receiver here. But if it is determined that I ultimately do sue them, or just even for them right now on a PR standpoint, if you're asking the state to allow you to do one thing and there's a problem over on the other side, you either may want to wait and see if we think that there's a problem for you on the other side, or you may want to act. That's just me as a general citizen, which is what I mean when I say that I'm watching what goes on in the news. I'm paying attention to it and who is doing it. And when names like Prospect come up in the news about these transactions, it's just one of those things that makes you look a little bit more intently at it. Sure.
I just have one question.
Sure.
Twice you went before the judge with the fees for you and for Max Wistow. Now, are those fees still not coming out of the pension fund?
That's correct. So and again, I need to be completely honest and transparent with you. The fees are not coming from the $86 million that is what is invested and what is paying out your benefits. The money to pay those fees is coming from St. Joe's, the shell, and Roger Williams, the shell. Ultimately, at the end of the day, whatever money, according to an order that the court entered in connection with the 2014 transaction, which was a side prey order, is according to that side prey order, Roger Williams and St. Joe's are allowed to wind down their affairs and to pay all the debts of those shell entities so that they can be dissolved, so they won't have any debts, and everybody who they owe money to or who owes them money either pays or gets paid. Once all that is done, the side prey order seems to contemplate, and I say seems to contemplate because I don't necessarily interpret it the same way that everybody else has said. But it seems to contemplate that all funds remaining would then flow from Roger Williams would flow into St. Joe's, and then whatever St. Joe's didn't need for its wind down would then flow into this plan. So while I am being straight with you to say that the fees are not coming out of the plan as it exists today, I don't want anybody to think I'm doing lawyer doublespeak. They are coming out of a pool of funds that ultimately, at least by some people's interpretation, would ultimately be funding this plan. So whatever I get paid from those funds, there's going to be that much less to go into this plan as a result. So I just want to make sure that I'm being upfront and honest with everybody as to how that's being done.
Thank you. I had a lot of emails and questions about that. Thank you.
You're welcome. Any other questions? Yes, sir.
Speaking of PR, there have been hundreds, many hundreds of TV ads for charter care.
Yes, there have.
Who's paying for all that?
I believe Prospect Charter Care is paying for all that. I don't know what the actual, what the bill is. Well, you'd have to ask Prospect Charter Care what they believe those ads will do for them and what their intention is for those ads. But there are a lot of ads. I've seen them. You can't miss them. They're very well done. They're very well done, professionally done. I don't know, again, I don't know how much they've spent on marketing, and I don't know what their motivation is for that. Is that because of deals like the Memorial Hospital deal that they're trying to do? I know they were involved in the deal with Brown University as well. Or is it this, or a combination of all of them? I do not know. But I'm as aware of those ads as you are. I see the same TV that you guys see. I listen to the same radio.
He stole my thunder. That was one of the questions I was going to ask. It's got to be costing them millions and millions of dollars to do those ads. They're on the average of, every 15 minutes during prime time? And they're now on the radio also. I am composing right now a letter to the editor that I'm going to send in questioning what's with charter care. Are they trying to dump money? Or what are they trying to do? Okay?
I hope it gets published.
I hope it does too. But anyway, I can't remember what the other question was that I know. I know what it was. At the March 29th hearing,
Yes.
the judge mentioned that he had received something in his chambers
Yes.
about is that a way to solve this problem? Is that something you can share with us? Or is that confidential information?
It's not confidential information. It was actually provided by one of your fellow pension holders who looked at it and kind of did their own analysis as to what they thought might be a way to help save the plan. I've looked at it. I've provided it to the advisor that I've retained for this matter, the one I said that is helping me with Mercer. And what I will do is I will reach out to the individual. I will ask if they have any I don't have any objection to disclosing it and putting it on the website for anybody to view and see. But because they provided it to the judge, not to me, the judge provided it to me as a result of my role and my relationship to the case, but it was provided to the judge directly. I want to just check with that participant just to make sure that they don't object to it.
Okay.
And if they don't, I will put it on the website.
Great.
And if they do object, I will let everybody know in one way, shape, or form that I'm not putting it up and it's because they don't want me to.
Okay.
I find it hard to believe, knowing the communications I've had with the individual, that they would have a problem with it being disseminated to the group. But I'm not going to try to figure out what somebody may or may not be thinking on a given day.
One other question I'm not sure anybody in the room is aware of, you may or may not have seen it, that CharterCare provided a grant to a dental clinic in Woonsocket for, I believe it was $10 million to buy new dental equipment, etc. Is that, I'm paranoid, is that dumping money too?
I'm not aware of that.
It was hidden somewhere in the news and somebody sent it to me.
I'm not aware of the circumstance. With
Okay.
regard to dumping money, I can tell you that if I and or special counsel were worried that somebody was trying to shed assets, Prospect's a very large company. And while to you and I, 10 million or the 14 million that was given in the 14 transaction is a very substantial sum of money, I can tell you that in my dealings with Prospect, which predate the St. Joe's pension problem, They are a wealthy company. They maybe aren't as wealthy. They're obviously, if that's a true story, they're $10 million less wealthy than they were the other day. But at this point, it does not appear that we need to be worried about them dumping assets with $1 million here or $10 million there.
Okay, thanks, Steve.
Sure. Any other questions? Normally, I say it was nice for everybody to come out on this terrible night, but it seems that spring has finally gotten here, so it's not as bad to drive in this weather. It's lighter out and it's warm. But does anybody have any other questions? I am going to continue doing this. We took a break right around the holidays. That's why it's been a little bit longer since we've met. But these meetings, I think, are important. I believe that the judge agrees with me on that. As I've said many, many times, both to you, to members of the press, and in court, in order for this process to be successful, transparency is key. I'm requiring it, and special counsel is requiring it from the people we're asking for documents from. And I expect people to require it of me and my office. Special counsel a little different because he's got to strategize with litigation, and you can't be that transparent before you file a lawsuit. But this process helps me to, one, understand what's out there that you are concerned about, and helps me to not only understand that, but also to address it to the extent that either I can clarify or I can correct some misconceptions. So just for everybody who's here and everybody who will ultimately be watching, these meetings will continue. And if there's a decision to stop, I will let you know in advance of that. But you can rest assured that we'll continue to do these at least on a month, every 4 to 6 week period. Yes.
That sum of $8.2 million
Yes.
that was presented to the Rhode Island Foundation, do we have any idea whether any of that should be coming back to the pension plan?
Not yet. That's part of the analysis that special counsel is doing. As you know, we subpoenaed documents from the Rhode Island Foundation. Those documents, that was a little strange to me personally as to the resistance on providing those, because I just saw the Rhode Island Foundation as a vehicle for those funds, not necessarily, they didn't do anything wrong as far as I would have guessed or could have guessed. But whether or not we ultimately make a claim to try to unwind the transaction that resulted in them getting those funds or a portion of those funds, that's part of what the special counsel and I will be discussing. While that's litigation, it's not the same as if we were to say we're going to sue the diocese or we're going to sue Prospect. It's still a lawsuit, but it's a different flavor of one, but it'll be discussed in the same context. Any other questions? If not, I thank everybody for coming out. Again, the website, we continue to post documents as they become available. I will check on that one from the participant who provided the document to the judge, and it will be posted if I get permission to do that. You can still always use the email and the phone, and you'll be getting notices of these meetings as well as court hearings. Like we said, the next hearing, unless there's an emergency with regard to a motion to compel with Prospect or something like that, my next planned hearing is May 30th, 31st. Okay? Thank you, everybody. Have a good night. Drive safely.